Hello, good morning, and welcome to our latest Bath Life event designed to help you in your business. This is a special Bath Life Business Surgery with Mogers Drewett. It'll be across several of Mogers Drewett's disciplines, including, but not limited to, so as lawyers want to assert, dispute resolution, such as, of course, the big insurance claim story which broke recently, employment and HR, corporate and commercial issues, and also touching on property, specifically commercial property areas. What practical advice do you need now, right now, for your business? Commercial property and premises, how should your contracts change in the light of the pandemic? How has the pandemic affected legislation, which in turn affects you? Employment rights, obligations and processes, again, what has changed and what may change going forwards? Brexit impact, now, right now, but also what does it change going forwards and what do you need to put in place? And how are you preparing as businesses for the great reset of 2021, which we're all very focused on? Ask any questions and we'll seek useful perspectives for you. Please send your questions using the Q&A button at the bottom below. You can ask anonymously or be named as you like. Please do add your name to the company, your company name to the question if you would like your company to be mentioned. It helps to give context. Anonymous is absolutely fine if it's more disputatious or difficult. Please note, today's business surgery, as ever, is being recorded and will be on our Bath Life YouTube channel later this afternoon. You'll find all our sessions on there, by the way. It's a sort of a chronicle of these times, as well as a repository of useful advice and insight. Some news from Bath Life and some of the stuff that we've been doing before we get going. We've got a next Bath Life Business Club, our panel session, currently slated for March 15th. I think that's the Ides of March, so beware of that one. The clubs, as I say, are panel sessions focused on individual sectors and how they're responding. All of us, as I say, are gearing up to this great reset, getting ourselves match fit and ready for the better times ahead. There's also our next business surgery with Bath by Uni later in Feb. It's about iStart, concerning skills and reskilling. Again, a vital area for us. These Bath Life business surgeries are bespoke, deep dive sessions showcasing companies' expertise from any sector through discussion. Please talk to us about how you might be involved. We can all do with advice, and of course, companies can all do with new business. A couple of notes on the awards. The Bath Property Awards at the Bath Property Symposium will be on March 12th. This is a rare opportunity. I'm almost into estate agent language here, but not honest. It's a rare opportunity for professional services companies to network, to build relationships, and to start to refill their business pipelines this year. All of us have been thwarted one way or another for quite some months. So this is a chance to come together for a three-stage symposium. High-level insights, celebration of excellence in awards, and a unique way of networking. It'll be the biggest gathering of professional service companies since before the pandemic. Last remaining hubs, those networking hubs, are available. They are with bespoke networking opportunities, broadly similar to a hospitality box at the rugby. The keynote, we're delighted to say, is provided by Knight Frank's head of Resi Research nationally, Chris Druce. We've commissioned him to give insights on some of the continuing trends from 2020, and more particularly the forecasts and expectations in 21. Valuations, transaction levels, given the pandemic, Brexit, stamp duty effect, working from home, much more. It'll be a fascinating event in its own right, that one. Tickets are on the website and there's group discounts. Of course, it's Mogers Drewett itself, the subject of today, who are the headline sponsors. Our thanks to them and our category sponsors, Orchid Joinery, Interaction, L&C Mortgages, Spaces, SWBF, and of course, Bath Life. And our feature sponsors include Triangle Networks. Bath Life Awards. Last week we had a very lovely Bath Life launch event. It was in many ways it was quite emotional. We announced the new date of September 9th. That wasn't the emotional bit. It was the opportunity to see some former winners, sponsors, contributors, and also just to relive some of the highlights from previous years. The recording of that is on our YouTube channel, Bath Life Awards. So it is that realization of all that we've missed, of times together, and it was lovely to hear, including, of course, from David Flatman, our columnist and irrepressible host, as well as our MP, Vera Hophouse. The noms are open, sponsorships are available, and it's perhaps worth considering after this year of all years. for proud Bath companies, or maybe those with great ambition. You'd be in good company. Quick run through the roster: headline sponsor, Royal Crescent Hotel and Spa, Apex City of Bath Hotel, Bath Audi, Bath Life. Clearly PR, new this year, which is good to see. Enlightened, Hotel Indigo, Marsh Commercial, Minuteman Press, Novia, Savills, Spaces, Stone King, True Speed, and our feature sponsors, Freestyle Design, Sub13, and Triangle Networks. Again, so push yourselves on your noms. It's really good to do for your company, but also for your team. As ever, thank you for your support for Bath Life. I'm just going to hold this beauty up here. For those who are aware of such things, this has gone absolutely crazy on Insta. There's a really splendid feature about Bridgerton, the TV show, but of course, its relationship with Bath. There's a lot of exclusive coverage there and so on. It's an example, we hope, both of the creativity that can be achieved even in these times. It's an astonishing feature, but also about the support, promotion, sharing the joy, sharing the love of Bath, which we seek to do issue in, issue out with Bath Life. And please do talk to us about how we can promote what you're doing as we get ready, all of us, for the better times ahead. Talking ahead, let's get on with the business surgery this morning. Please, as I mentioned, ask those questions. The earlier you get them in, the more chance we can include them if you wish. Let's bring forward our experts from Mogers Drewett. They are Maeve, Natalie, and Sean, and I'll talk through their bios as they are coming to life virtually in front of us. Hello and good morning. So Maeve England, partner and head of litigations dispute team at Mogers Drewett, specialising in real estate, commercial property, and commercial disputes. Clients range from individuals and companies to national, even global organisations. Maeve has done at least one business surgery previously, whereas Natalie, who's joining us, this is your first business surgery, and you've been with Mogers Drewett all of 3 weeks. We'll probably pick that up at some point. So welcome, Natalie, who specialises in real estate development and commercial investment matters, developers, national house builders, institutions, corporate occupiers. Natalie has significant landlord and tenant experience, advising on strategic land deals, multi-million-pound finance and refinance matters, acquisitions and disposals, and estate management. And Sean McDonough, something of an habitué of these Bath Life business surgeries. Morning, Sean, a specialist employment lawyer at Mogers Drewett, significant experience of working with both employers and employees, protecting employers against the risk of claims, offering advice and support for employees if and when disputes arise. Sean also provides employment and HR training for clients. So there you go. Welcome to you all. How are you all doing this morning?
Very well, thanks, Greg.
Well, thanks.
All fighting fit and ready for this. It's not a battle, but it's a thing anyway.
Always. Yeah.
We'll be going through a whole load of different areas, but I'd like to begin on a slightly more general point at first. We can all begin to see the beginnings of the hints of the early stages of the end of these times. I hesitated to put it too optimistically. Businesses are gearing up for this new world, getting match fit for the challenges ahead. What would you advise in terms of contracts? Business as usual, just get on with it, or review what you're doing in this changed world? Who'd like to start us off?
Well, okay. Well, we're both now talking over each other. I'll kick off. We've all been sort of very focused on a very specific set of circumstances which came out of the blue and took everyone by surprise. So we've been focused in on the contracts that we now have and how to deal with it to get our business basically to put up the best possible defense to all of the various problems that we didn't anticipate before. Nobody really thought there was going to be a pandemic. And so even that very recent insurance test case with the FCA, in a way, they were sort of shoehorning a set of circumstances in that arguably were never really intended to be part of those contracts, but still, for public policy reasons, etc., they have done so quite imaginatively. But so I think I would say, whilst we're still really coping with where we are, it's time to really take a look at our future contracts. So if you have the opportunity of entering into new contracts now, we should be thinking about much more broadly in terms of how we need to deal with unusual circumstances when they arise. So looking forward, really.
And in a sense, that's a key part of any law firm's role, is to almost to imagine the unimaginable. I've heard some contracts described as you negotiate the divorce before you've even got married, metaphorically, of course.
Yes, I suppose so. Yeah,
But
I
of
suppose
course,
so. Yeah, to avoid people like me in the future, sort the contracts out now.
but isn't it, there's an oddity here that as business owners, and partly talking about us, but for many who we talk to, we're all reviewing the way that we work, the whole working from home and technology thing, and our changed offerings from deliveries to opening hours, when we can open, to e-commerce, even to virtual events like this. And yet, very few of us are actually reviewing the bedrock, their contract and terms of trade. Why so, and what practically should companies be doing now in what passes for a quieter time?
From an employment point of view, Greg, I think businesses, a bit like Maeve has described, there was lots of panic and lots of concern at the start of the pandemic, and lots of relying upon the goodwill of workforces to be flexible and all of those types of things in relation to working from home and reduced hours and all of the measures that people put in place. But lots of sectors have been thinking quite a lot about how they trade post-pandemic. I think a number of those sectors thought those plans would already be in place now, but they haven't been, because it's obviously going on a bit. But I think it's all about flexibility. We had a session last year where we talked about trying to decide what you wanted to look like as a business the other side of this. That's still a very relevant question if you haven't made that decision. And then what flexibility do you need to build in to your contracts, your policies, your procedures? We would suggest you build in a whole range of flexibility to deal with those issues.
Sean, could you be a little bit more specific on this when you say a range of flexibilities? Perhaps give an example of the sort of things which employers should be anticipating and seeking to build into their employment contracts, whether reissuing existing ones or, of course, new ones.
Hours of work. So flexibility around hours of work. You are typically, or you were prior to the pandemic, typically employed on a full-time or a part-time basis. Very few jobs operated on a flexible time basis. But I think employers will increasingly want people whose hours they can vary in certain circumstances. Things like mobility, so where you work from, typically that will be you work in the Mogers Drewett Bath office or whatever it might be. I think flexibility will be needed around that. Redeployment of staff to cover staff who are off sick or who are shielding. So although the vaccination program is great, I think the COVID will be around for a while, so there are going to be ongoing problems with attendance. So redeployment, layoff, those types of provisions. So that type of flexibility. The trade-off will be how attractive or otherwise your recruitment looks to the outside world. So if you're employing somebody with all sorts of different flexibility built into their contract and somebody else isn't, then you're going to struggle to attract the type of people you want, I would have thought.
How about someone who has a fairly standard employment contractor, asking for a friend here, who maybe has 7.5 hours a day with defined times with an hour at lunch and all the usual stuff, the cookie cutter approach, which many of us have to that aspect of employment. Does it actually matter that whereas hitherto it was 9 till 5 or whatever, whereas now it's we wish people to do the work they do, and we're not just agnostic about when those hours are, but we have to be flexible when it comes to homeschooling parents or whatever the iteration of personal life. Do we really have to rewrite all those contracts and get approval?
Short answer is yes. It doesn't. Commercially speaking, it doesn't really matter, because if your workforce wants to work in that way when you need them to, and they're happy to, and the consent and all the rest of it, then there's a very low risk of there being a problem. But you do have to provide certain bits of information in the contract throughout the employment relationship, hours, place of work, those types of things you do have to confirm. So if you do want to move to a far less structured approach, you need to have something in the contract that deals with that. And you also need to be able to manage that system. Not everybody has the type of workforce where that's going to be straightforward. So something in the contract to reflect the new structure and a policy around managing that process as informal as you want it to be would make sense. I think.
It's certainly, as a piece of advice on this, it's certainly worth checking standard employment contracts.
Definitely, yeah.
I mean, many will have a little catch-all saying, or any other such times as may reasonably be requested or agreed, or some such.
Well, one very, very dull, or previously very dull example of a term in a contract that 10, 15 years ago was in every employment contract, and in March was in not very many employment contracts, was a layoff and short-time working provision, which allows you contractually to lay off members of staff in certain circumstances. That had dropped away because there was a very sort of manufacturing-based term, whereas I suspect now lots of contracts, professional services, all of those types of contracts will have that re-included because it gives you that flexibility.
As ever, of course, a more specific, detailed advice, please do talk with Mogers Drewett, and I guess there are other law firms in the city who broadly comparable skills. We're not talking about them, but please send through your questions. This is an opportunity to try to discover what we should each be doing. Let's come on to the joys of the furlough scheme, not how it operates. I think one way or another, most businesses have been operating at least adequately since April under the furlough approach. It's due to come to end at the end of April. Come what may, do you think it will end then? I mean, the CBI, amongst others, has called for another extension. Yeah,
there's been a lot of, in the last week or so, a lot of calls for it to be extended or varied, tapered off, become more focused, those types of things. I think it probably will be varied in some way. We may get back to a sort of tapering system that we had towards the end of last year. It may become very sector specific because, a number of sectors are trading perfectly well at the moment, and in spite of the virus, they've adapted very quickly. But obviously, the leisure industry is still very, very in very significant difficulties. So it would seem counterintuitive for the scheme to just stop in April when bars, restaurants, gyms, all of those types of businesses are still closed. So I would expect some further flexibility, whether it's more focused. I also saw something over the weekend about additional funding for training, retraining employees who are made redundant. So the coronavirus job support scheme, it looks like it will be more than just wages during the furlough scheme, which I think would be useful in the longer term.
Sorry, could you just amplify a bit? More than just wages? Be a little bit more on that.
So training, redevelopment funding for employees who are losing their jobs and having to switch careers, those types of things. So I saw a reference to that in the papers over the weekend. Sunak is being asked to fund those types of measures as well. So trying to protect people's jobs and then enable them to transition to something else, whatever that might be once the virus is over.
Let's bring in Maeve and Natalie on this point. Clearly, how one defines it, the pandemic has been a seismic shock in wholly unrelated ways, but specifically here around business. What do you expect the sort of regulatory and legal environment? How do you expect that to change in your areas of expertise going forwards? What's going to be different?
Well, Natalie, shall I hand over to you on that?
I think from a property perspective, from kind of a landlord and tenant perspective, we're going to be seeing a lot more lease re-gears, a lot more kind of renegotiations, whether that's shorter terms, whether that's lesser rent, whether that's more break clauses. That's what we're seeing a lot more of at the moment. And then obviously if landlords and tenants are kind of in dispute about payment of rent, or a tenant trying to vacate under their lease, there are means that we can obviously deal with that.
I mean, I agree. I think that I have seen, although I deal with disputes, of course, a lot of what we do is advise about avoiding disputes. And if one thing this pandemic has thrown up is the need to have business relationships with the people that you're dealing with. You know, it's so adversarial in our system. You know, when you go to court, it's going to be claimant and defendant, and everything we do seems to be geared up that way. But the best resolutions I have seen have been people who are in very good contact with their landlord or their commercial tenant, because landlords don't want empty premises. Commercial tenants want to be able to continue their businesses. So, you know, you need to talk. And sometimes, I know this question was about what regulatory things are going to change, but actually, it isn't always, the answer isn't always what's the correct legal clause to fix this. It is basically just about being human beings and talking. So I've seen a sort of creep in of more imaginative thinking, the sort of thing that a court wouldn't be able to do. So you go to court and you'll get damages, or you will get an injunction or something like that, but you won't get, the court won't be able to say, okay, well, you landlord, why don't you give a share of profit to your tenant, and then your tenant can in that way survive a bit better, and you or the other way around, or that you get a sort of turnover rent used more imaginatively. In terms of for example, you have in retail, you do see that sort of imaginative approach, because otherwise you're going to have lots of empty shops. So you get landlords who will drop the rent a bit, but they want to come back when times are good, and that's a sort of sharing of risk. But you see it less with other types of companies where it's not retail. But for example, I think that we'll see more of a creep in of like a good commercial company who's a tenant, but who has suffered under the pandemic because of their own business interests, and who's prepared to offer their landlord a share of equity, for example, which is so that the landlord doesn't have to take a huge hit and carry all of the loss on behalf of their tenant. So I expect solutions like that to come more to the fore, rather than something changing in terms of regulations.
I mean, that latter point makes me think that some of those dot-com companies, the late 90s and early noughties, were always the harbingers of new ways of doing business. That equity for rent, or rent for equity, was exactly what early stage businesses did, because they didn't have money. At that point, they didn't have funding, so they played whatever assets they had. You're saying that as though you're anticipating that. Are any of you seeing any of that more imaginative approach to broadly dispute resolution, or anticipating disputes down the line? Is already happening, Maeve?
Well, it is creeping in slowly. People aren't that keen to give away their equity, as you can imagine. But I've sort of just read around about that and seen that. I think actually that there are probably people listening to this who are commercial landlords or commercial tenants, who themselves are thinking of very creative things. Not everything is the preserve of lawyers. And I am interested to hear about more imaginative approaches to this, so that it isn't always a legal answer.
Go on.
That said, there are legal pathways as well. So I think probably in the future, in terms of contracts generally, there's going to be that the old force majeure clause that used to lurk in among all the boilerplate sort of provisions at the end that nobody ever looked at really, has been promoted and is suddenly of much more interest to everybody. So that is going to get a lot more attention, because otherwise everything is too sort of left to chance. So defining what happens if another pandemic comes along, I expect I'll see a lot more of that in contracts. And like Natalie said, a bit more imagination around break clauses, etc., in leases.
And in terms of that imagination, it's clearly not solely confined to equity. It could be some sort of upside as the business recovers. It's a deferred payment, but a larger amount later than currently, from a cash flow point of view. Again, that sense of imaginative problem solving. I'm guessing that you as a firm would see yourselves as a catalyst to that. So. Any further iterations of that degree of imagination of problem solving?
Sorry, Natalie?
I'm just going to add, I think from a property perspective, we've also got the option of perhaps monthly rent payments as opposed to the usual traditional quarterly rental payments. That might help with your tenant not being able to maybe pay one lump sum every 3 months. A kind of a slightly smaller amount every month might help. So perhaps not typically creative, but I am seeing a little bit more of that.
Yeah, I mean, ultimately, to pick up one of Maeve's points, business starts with a conversation, but so does problem solving.
Yeah.
Either it's the direct one-on-one with suppliers, tenants, landlords, leases, whatever, or it's through an intermediary such as Mogers Drewett, of course, here. Sean, you're about to add something to this?
No, sorry.
Well, don't worry. I'm going to nail you now with the working time directive. I'm sure you're infinitely au fait with that. It's about the workings of it. It's more about to come on to the Brexit point, which increasingly becomes centre stage for many businesses. There was a lot of talk about the working time directive being changed, that the UK now has agency over its employment laws in a way it apparently didn't previously, that there is change coming. Are you anticipating those changes to employment which have been talked about?
Yes and no, really. So the government have announced a review, haven't they, of employment practices post-Brexit. The reality in relation to the working time directive or the working time regulations as they are in the UK is that the UK have opted out of that bit of them since the start anyway, along with 17 other member states, by the way. So they haven't quite had the appeal that we're told they have. So will that opt-out be enshrined? I suspect it will. I suspect the requirement to opt out will be dropped at some point, potentially. There may be the problem with the working time regulations is that they're very complicated and they're complex.
Isn't that grist to the mill for you as a lawyer?
It is for me, but clients loathe them. Care homes, those types of clients, so they're very difficult. The rest breaks, the maximum working time, how having a second job with a different employer, how that plays with working time records and all of those types of things. It is probably unnecessarily complicated. So do I anticipate those rights going, those protections going? Not completely, but I think they will be simplified. I would hope they would be simplified.
But no material changes to be anticipated, at least at this stage.
Not at this stage, other than maybe the maximum working week bit coming out. But again, the reality of that is very different. So what the regulation, without going into detail, the regulation actually says is you can't work more than 48 hours a week over a revolving 17-week reference period. And not many people do in the UK. Not many people do that anyway. So you might opt out in your employment contract, possibly without even knowing it. But even if you didn't opt out, the reality of you breaching that very often is quite slim. So,
given that we're all self-evidently working from home in these times, and we'll have almost every sector will have a greater degree of working from home in the future, are you expecting regulatory environment in any way to change around that specific point about working from home, employers' duty of care, anything connected to that, as opposed to the traditional workplace approach, which we've all adopted for a couple of seconds?
There have been difficulties over the last few years about working out or trying to arrive at a tidy definition of what working time is. There's been lots of cases about travel to work or sleeping if you work in a care home or if you're a security guard, those types of jobs. And those roles have clashed a bit with the regulations because working time under regulations is nice and clean. The environment we're now in is less so. So there may be some fallout as a result of, how are we measuring people's working time who are working constantly pretty much whilst at home? If you're in the type of job that lends itself to home working, I would have thought most people are working more rather than less during the current crisis. So how is that measured? versus how we traditionally measure time, which is seeing somebody sitting at their desk, which I've always thought was a rubbish way of measuring work output, by the way. But yeah, so there will be some shaking out of those types of things, I would have thought.
And again, from an employer's point of view, and related solely to employment at this point, are there any other changes that we as business owners should be anticipating related to Brexit changes, if not pandemic changes, or indeed both?
There may be some other areas of employment regulation that are changed. The government say they're not going to be ripping up workers' rights. So we'll wait to see what happens there. I personally am not expecting them to be honest. Brexit, I guess it's the medium economic implications that are the chief concern at the moment. We've heard lots of stuff in the press about trading difficulties and those types of things. I don't think they've filtered through yet beyond the sort of chaos that is still going on about the pandemic. But as we get into the summer and the COVID starts to the restrictions start to ease, will the easing of those restrictions be impacted by Brexit-related difficulties for those sectors? Possibly, but it's difficult to say at the moment, Greg.
And are you expecting or advising even on potentially more fixed-term contracts as opposed to open-ended employment contracts, whether it's the pandemic, possibly Brexit, but that everything is a bit more contingent now, so we will be reflected in employment terms as well?
Yeah, for sure. I think clients want more flexibility, which we talked about. So fixed-term contracts, I know it's been a bit of a dirty word, but 0 hours contracts as well. 0 hours contracts don't necessarily have to be working in one of Mike Ashley's warehouses. You know, they can work well depending on what sector you're in. So properly administered 0 hours contracts may well come back into fashion a bit. But yeah, flexibility is the key.
Why would either side choose a fixed-term contract? The area I'm most aware of is football managers and similar. They tend to be defined terms, or football players tend to be defined terms, which then become cliff-edged, renegotiated or sacked or whatever it is. They don't tend to exist quite to the same extent in normal course of business. Why would they be attractive to either side now?
You might have a particular business need to service over the course of a very specific period of trading. So that might be one reason. You might have funding in place if you're a sort of public sector organization or a quasi-public sector organization. You might have funding for a very specific project or role, that type of thing. You might have maternity cover, those types of situations.
Let's come back to property with Natalie. Tell us, as of now, this first few weeks of the new year, what levels of interest, levels of business activity you're seeing in the commercial property sector compared with previous years? Transactions, valuations, up, down, sideways?
Yeah, it's very busy. It's extremely busy. Whether that's landlord and tenant, acting for landlord, negotiating a new lease, acting for tenant, whether it's acting for seller or buyer of commercial property premises, is exceptionally busy. The stamp duty holidays obviously helped. Whether this will be extended or not, we don't know at this stage, but I think that's definitely helped, not just for residential transactions, but also for commercial transactions, but it is exceptionally busy.
Why has the residential stamp duty point affected the commercial sector as well?
The SDLT bans have changed somewhat. So, for example, if I was acting for a developer might not be paying so much initially on the kind of beginning part of the price of the transaction. So yeah, the bans have changed somewhat, which I think has probably helped steer the market as to where it is at the moment.
Well, the Mogers Drewett conveyancing team, like all conveyancing teams of all legal companies, have got 7-8 weeks or so to get deals done. And I just wondered, given the benefits of getting a deal done by March 31st, assuming no extension, and the pressure to get it done, whether that will trigger disputes, and what at this stage can be advised on either side of that scale? I know this is residential, but it's a principle of dispute resolution. What can be advised to help transact or to mitigate the issues of delay to those transactions?
I mean, what I'm putting in my contracts, if parties are trying to complete before the 31st of March, I mean, we're doing our best to complete. I've negotiated a couple of clauses whereby the difference in the STLT has been or will be deducted from the purchase price if we do kind of trickle into April. A couple of cases that hasn't been agreed, but I mean, that's one way you can kind of get around it. In terms of a potential dispute, Maeve, I don't know whether you can foresee anything post-April.
Well, I think that in terms of with property deals, the deal isn't done until it's done, is it? It's not like other commercial deals where you can just sign a contract. You have to exchange before it becomes binding. So I would have thought that you would set your completion date, and then you know, the contracts usually deal with what happens if you don't complete on time. So where the contract deals with those provisions, it's dealt with. Any ability to claim SDLT back because something didn't complete is possibly a question of damages, but it would have to be significant before you would want to take that case to court. So what Natalie's doing, which is thinking of it now and having the contract deal with it, that's the way to deal with it, really.
Yeah, and I guess the whilst it's painful, at least it is capped. It's only up to that 500,000 level, so it's finite, the gap, but it's still a painful gap for individuals and of a scale, presumably for developers. I wondered also, there's been talk of COVID-19 related clauses on leases. Perhaps you could tell us what and why, and should all signatories of new deals be cognizant of this, or is that a bit of a chimera?
Sorry, Natalie, you crack on.
Sorry, Maeve. I was just going to say, I think it depends on the bargaining strength of the parties involved. I've tried to negotiate a couple of COVID-19 clauses into my leases when I've acted for tenant. Now, these clauses allow for the suspension of rent whereby tenants' premises have perhaps been shut because of a lockdown. They're unable to trade, unable to meet rent commitments, and landlords have just, you know, come back and said, no, we're not agreeing to this, the deal is the deal. So I think it very much depends on the bargaining power of landlord and tenant, and the communications and the relation, like Maeve said at the beginning, the relationship between the two parties is key. So the communications between the two as to whether that clause gets inserted or not.
Yeah, I personally find sometimes, and this is a willfully optimistic approach to dispute resolution, that sometimes it is actually better to have had a dispute if it is well resolved than not to have had a dispute at all. Parties actually open up and share their perspectives and reach a point of commonality. Maeve, is that pie in the sky?
I think that I think that must come down to your nature, Greg.
I don't know about that.
That's not always the way it works out. You know, I think actually, well, I suppose in one sense, in that the vast majority, huge percentage of disputes never go to court. So then it's settlement, and then you're right. That's about preserving relationships and being able to work beyond the dispute. So yeah, in that sense, when they settle, yeah, it can improve relations because it clears the air.
Yeah. Let's come on to, we've touched on it already, we've been skirting around it a little bit, the Brexit issues. This is probably primarily for you, Maeve. Talk us about some of those supply chain issues you've been witnessing with clients. It's meant to be friction-free as we traipse towards a sunlit uplands. What do you think?
Well, we're sort of in a period of uncertainty at the moment. Let's face it, nobody quite knows how it's going to fall out at the moment, do they? All they know is that there are blockages. So what we're getting are questions to do with, is the current situation enough for that contract to be over, terminated, because, or has the thing that we mentioned from time to time, the word frustration in its legal sense, has that occurred because of all the circumstances that have happened? And that will come down to each individual case and each individual set of circumstances. So just without going on about frustration. It has to be like an intervening event which wasn't caused by either party, which the contract doesn't already deal with, because if the contract says in the event of this happening, then X happens. If the contract does that, then you're not going to be able to claim that the contract is terminated because it carries on operating. And the thing that happens has to so significantly change the contract that it can no longer be performed. That's it in a very, very broad nutshell. So if something is making the performance of the contract more difficult rather than impossible or more expensive, then just by operation of law, it's not going to be found to have been frustrated. So what people often talk about are force majeure instead. And so there's a sort of blurring of what's force majeure, what is frustration, and people talk about a force majeure event, whereas actually in English law, force majeure isn't a sort of freestanding concept. It's a thing that's either in your contract or isn't. And so that it will come down to what the parties decided, where circumstances in which either obligations would stop under the contract or they would be changed somewhat. And that changes contract by contract just on the wording. So in English law, it's not a freestanding concept. However, if you have international supply contracts in other jurisdictions, it can be a freestanding concept. So for example, in French law, it's codified, it's in the civil code. And there, if you haven't got a force majeure clause in your contract, then they will imply one in, and there will be a default one in there. So if you're doing deals internationally, you need to be aware of that.
Anyone doing deals internationally needs to, they're already experiencing it, I suspect, but they need to be caveat emptor, treading very carefully.
And then of course the key is, what's the law of the contract?
Yeah.
You know, is it English law and jurisdiction, or is it some other jurisdiction and law?
Can you just talk through an example, because many of us won't be as familiar as you, of course, with the concept of force majeure or indeed of frustration. What might constitute force majeure? For example, if supply chains through Dover are down, delayed materially or whatever, does the act of Brexit and its consequences potentially constitute force majeure, or is it better to deem it or to argue that it's frustration? You can tell them into a grey area here. So talk
no, that's okay. So whether or not there is a force majeure will depend on the contract. So that supply chain, for example, say you are business in Bath and you are importing widgets from Germany, and they are not coming through, or maybe something more likely is something which involves animal products, which have so many more regulations and paperwork, not all of which I know by the way, or at all. That can really complicate. So say your widgets are coming and they come in a lorry that typically also carries over, when it comes, animal products, and then everything has to be checked by vets and everything gets held up, etc., etc. Whether your force majeure clause in your contract that you cannily thought of 2 years ago deals with that situation is a question of interpretation of that contract. And if that contract's under English law, it would be English law that sets the rules about how that's interpreted. So that's quite straightforward. If there's
actually, I have to say that wasn't that straightforward. So if it's going to get worse, happy to.
Well, I'm not saying in practice it will be straightforward, but the idea is that force majeure is just the contract. It's either there or it isn't, and the way it works, what it means depends on English law and previous decisions, etc. If you don't have a force majeure clause and it's under English law, then potentially there are going to be frustrating events. So, for example, it's hard to get a definite example at the moment on Brexit because it's so early days still. But for example, a different contract was the Canary Wharf contract, where there was a European agency that had rented premises in Canary Wharf, I think in 2014. And then Brexit happened. So then they said, right, well, you know, if Brexit happens, this was before the vote, then we're going to say that that contract is frustrated. And that was actually a lease, but the court decided that it wasn't frustrated because it was the European agency that had set the rule that said that this particular agency couldn't work outside the European Union. Of course, once Brexit happens, it's outside the European Union. But the court said, well, your European father company can or agency can change that. So it's your own. It's by your own doing that has happened. So in that case, it was unsuccessful. In terms of frustration of contracts for imported goods and exported goods, I've come back to what I said before, which is if it's just more difficult to do it or more expensive and more onerous and lots of paperwork, that's probably not going to be frustration. If
I could give you frustration with the lowercase f, we've just had a comment from Anne Twitchett at Round Hill Roastery. Green coffee beans stuck in port for a month as no one understands the paperwork. Frustrating with the lowercase f, but what she or others in similar circumstances, what might they be able to do? They've got obligations and they've got need at the business end to use whatever the things are, in this case, coffee beans. They can't get them.
Well, it depends. I suppose if it's product that goes off, that might make a difference. If it's product that doesn't and it's more difficult, bearing in mind that the doctrine of frustration is one that I don't think the courts are keen to extend. Bearing that in mind, and bearing in mind that for public policy reasons, the government probably doesn't want Brexit to look like a disaster. There may not be much willingness to extend that, but there will be test cases on that sort of situation. I would say at the moment, for a situation like that, the starting point is the contract. See if there's anything in the contract which gives you a remedy. Other than that, then, you know, arguing that you could always try to argue that your case, the contract is frustrated. Whether you would succeed in court is up in the air at the moment, I'm afraid. No perfect answer to that.
I'm not commenting specifically on the Round Hill Roastery point, but as a slightly more general point, I'm sure goods are supplied in good faith, as they always have been, to one port. They are blocked and the recipient can't get them. Whose responsibility is that? And particularly if that is time sensitive, such as food produce?
That could be, I mean, that depends on who's not doing their job, why is it not getting through, has the paperwork been completed? There's so many variables in that it's impossible on a hypothetical basis to pinpoint who would be responsible in those circumstances. It's unbelievably frustrating for businesses, this situation, and it is really expensive, and it is business ruining on occasion, and all of those things add together to certainly lowercase, I would say all capital letters frustration, but in the legal sense, it's an expensive battle to go through a court with. There will be test cases, probably people with huge sums of money involved.
There may also be, and again, it's not specific to this case necessarily, there may well be trade bodies and representational bodies who are acting on behalf of their members, their organisations, exactly to test legal process in these times. There's another suggestion which the government, or at least some of its agencies, it's not quite clear how overt this is, they're sort of quietly suggesting that UK companies who trade inside the EU should set up EU-based subsidiaries to avoid tariffs, delays and conflicts. Apparently over 500 have already in the Netherlands alone, for example. Is that something you would advise, you would anticipate advising?
I think it's, although it seems crazy that's the government advice for what is meant to be a friction-free Brexit process, make it friction-free by staying in Europe, which is basically what they're saying. So trade in Europe for a Brexit-free, friction-free Brexit. Yes, subject to, you know, the 1,000,001 tax implications and all of those types of things that you'd have to take into account. We did act on a sort of a group reorganisation in December for that very reason, creation of a new company and transfer part of the business into a new company to get around some tax-related issues as a result of Brexit. So yes, lots of businesses are doing that. If it works for your business, it will be a tax-driven thing though, Greg, I think, rather than a strictly regulatory-driven thing.
Yeah, I mean, what about, for example, and there's myriad examples of retailers in Bath who have been pushing their e-commerce activities, far more actively. Many of whom, of course, will be exporting to EU countries, previous tourists here, or whatever. Should they consider setting up an EU-based sub precisely for that tax or regulatory process reasons?
Yeah, they could, but it seems a bit. I don't know how to do it, and it seems too easy to go, well, I'll actually have a satellite office based in Cologne, and then I'll avoid Brexit-related tariffs. It seems a little bit too convenient. So, but if it's possible to do that, it's probably more cost-effective to do that than it is to put your prices up to account for those tariffs, whatever those tariffs are going to be in the medium, longer term. And I don't think people know that yet. So it may be a little bit premature to make those decisions, but it may be more cost effective to have some plaque on a wall in a European city rather than suffer those tariffs, if that does get around them.
There are already some quite tough anecdotes about consumers having to pay huge delivery bills that were wholly unexpected on an item which technically has been routed through the EU or is routed in the EU, and that presumably will play through in time. So talk about, in our remaining 10 minutes or so, a little bit less. Clearly, we've all had this seismic shock to business. There is, at some stage, a prospect that, I'm not going to use a six-letter word beginning with N that suggests there's any degree of normality coming, but there are better times coming. How should businesses be approaching this time? Is this a sort of ground zero restart and afresh on all contracts? Mostly contracts are for drawers or for some digital filing cabinet. How are you advising businesses to approach this new time?
Yeah, it comes back to without sounding like a stuck record, Greg, it does come back to that flexibility. Have you got a sufficiently clear view of what you're going to be doing after the pandemic as a business? If so, you can plan for that now, and it's likely that you're going to want to plan in as much flexibility as you can, if you can, with your suppliers, customers, landlords, employees. So it's really about having that as clear a view as you can about what you want to be doing post-pandemic. I think most businesses would sit there and secretly think, can I just go back to the way it was before? But of course, we know I don't think that's going to be very likely. And it can be quite challenging for certain sectors to imagine a materially different future to the past they've had. So it's really gaining an understanding of what your business will look like and then planning around that. But flexibility is the key, which I keep repeating.
And clearly there's been a big surge in startups of entrepreneurs, new businesses, partly perforce because it's in the absence of traditional routes of earning money or whatever, but also because the Southwest is such a hotbed of creative commercial thinking. But any new businesses now, in whichever areas that you represent, what should they be thinking about differently now in comparison with had they set up in a year back in those pre-lapsarian days?
Well, I think funding is a big one, always has been a big one, but funding a startup now is probably trickier than it might have been 2 years ago. So how are you funding it? And how are you accessing your market? So that's not a particularly that's not at all a legal point, but how are you accessing your market and what protections you need to be able to do that? So I can't imagine there are many people who are thinking about starting a retail, bricks and mortar retail business in Bath at the moment, or anytime soon. So those traditional ways of doing things are gone, really, aren't they?
Well, sometimes zigging when everyone else is zagging does have its
possibly
somewhat high risk. I mean, presumably in terms of funding, there's so much capital washing around the system that it has to find a home. So there is money out there for
There is.
Discretion.
Yeah.
And I would say in that respect, reach out. There are organisations that do, don't do it on your own. Don't try and work everything out on your own. So, I mean, there are organisations, I mean, in Bath, there's the BID, for example, which on its website has set out what grants are available, etc. It's very hard to work that through on your own. So reach out and take help. And I would say in advance to startups, know your risks. So look at your contracts, they matter. I know they're the bit that you're not interested in. You're doing this sort of creative and fabulous bit, but this is going to be there. This is your security sitting underneath your business and the bedrock of your business. So look at your contracts carefully, know your risks, and to businesses who are already up and running and are in contracts that have a time to run and they can't change them. I would say at the very least, look your risk in the eye, and then you can plan for it, rather than having the contract in the bottom drawer under a pile of never looked at paperwork, only coming out when you've got a problem. Know your contract, take advice on it, and take mitigating steps to protect yourself as much as possible.
And is this something that Mogers Drewett either does or would consider, to have a sort of almost an open contract review session where you go through across the whole piece, the full range of companies' contracts, whether property, employment, commercial, because these are new times?
We have done sort of health check type things in the past, Greg, and it's certainly something we would do on an ongoing basis. I was involved in a Bath Spa business incubator session last week, talking to startups and new businesses, and I take Maeve's point about knowing your risk and understand them, but I don't think that's really in the DNA of your typical startup. I think largely they don't really. The reason they're starting up and they're being creative and they're entrepreneurial is because they don't want to speak to me about their employment contracts, because who cares? They're just pursuing their idea, and if something falls out the end of it, then they'll resolve it on the other side of it. But so there can be a bit of a clash between startups and lawyers, because we sometimes talk quite different language, and it's difficult to place that risk-based advice in the head of a startup entrepreneur, because they're thinking about different things. But yes, short answer is we do those types of health check things, but it tends to be with slightly maturer businesses.
Yeah, well, I mean, even the most beautiful hot air balloon requires ballast, and if nothing else, it's far more than that. But if nothing else, that's part of the service that you provide.
Absolutely, yeah.
And Natalie, for you with new businesses, are you seeing or are you anticipating greater use of flexible workspace? I'm thinking in terms of such as the co-working hubs, the guild spaces, etc. That new businesses, because everything is so much more contingent, there's going to be a growth in that sector. Is that something you buy into?
Yeah, I think so. And like I said earlier, perhaps the more formal leases, perhaps more shorter terms, tenancies, more personal arrangements. So that promotes the flexibility. But yeah, I think that will be the way things may go this year. Again, it's that risk weighing up. Do they want to commit to a 3-year lease or a 5-year lease or whatnot? Are we going to look at other options? So yeah, no, I think so.
Well, we're nearly done. This hour has flown by. I'd just like you to close, if I may, on one thing. It's always worse if you're the last of 3 to go, so don't someone dive in first. If you could give one piece of advice to Bath businesses about the approach to legal matters in these new times, what would it be? Single piece of advice.
Be flexible and open-minded.
Communicate with your landlord, with your tenant, with your lender. Just, yeah, communication is key.
A problem ignored usually gets worse, I guess, is the point that's lurking in there. It doesn't go away if it's ignored. Take it early. Yeah. Maeve, any last thought?
Well, I would say reach out, but I'm also going to be really dull and say check your insurance. Check your business interruption insurance. Sorry, I had to say
No, it's a really good one. It's a very good one.
All right, I said that as the last one, and of course it isn't. I'm just going to open one last point, which is there's quite some excitement 10 to 14 days ago when it was apparent, it seemed to be the case, that insurance could cover business interruption through COVID, and suddenly lots of small business owners thought, gosh, you know, there's funds to be had there. Is that true? Is it that straightforward?
Well, there was an FCA test case. It looked at 21 different policies covering about 370,000 policyholders. So huge impact, and it looked at the different policies, and basically, you know, the short answer is yes, there is potential for business interruption insurance because of COVID and because of government actions in response to COVID, and the court looked at that very, very closely. There were lots of questions, for example, about what's business interruption? Does it mean complete shutdown, or does it mean hindrance, you know, lesser? And it was found that it can just mean hindrance. It can be slight hindrance. There were questions about, you know, government actions preventing access to premises. Was that complete closure of premises, or could it be partial? And it was, you know, prevention of access can be prevention of access to part of a building, like the ground floor, for example, or it can be prevention of part of your business. So, for example, instead of a restaurant, you can only operate a takeaway. Of course, you have to establish loss. And then there were lots of questions about causation, which I won't go into here. It's too detailed. And also questions about what they call trends clauses, which are to do with how do you calculate your loss. So, you know, for example, say last year you had a terrible flood, and so your business was down anyway. The trends clause allows you to adjust to what you know, what theoretically your loss would have been. So it can be that can be up or down.
Well, as ever, I'm sure lurking in there is that point that correlation doesn't imply causation, and lawyers will have great fun trying to disinter the exact relationship between an act and a potential consequence. I think the point has been made by each of our speakers today that, amongst other things, please, for all of us, we need to review our contracts and to think about our business more differently going forwards, but also the whole reach out and touch, reach out and communicate, talk to suppliers, talk to lawyers. We had a point which has mysteriously disappeared off the Q&As. I won't name the person, who said that they were slightly fearful of talking with lawyers because of the cost. I guess the response to that is, well, pick up the phone, as it were, drop an email, see what those costs are, and to see if it is, you know, the materiality of loss is such that it makes sense to have significant professional legal advice from Mogers Drewett here today. Thank you to our speakers from Mogers Drewett, to Maeve, to Natalie, and to Sean. Thank you for all of you watching this and the questions today. Look out for the next Bath Life Business Surgery with Bath Spa Uni shortly. And it's great to see the university, by the way, engaging deeply with the city. Thank you again for all of your support for Bath Life, and good luck to you and to us all in the coming months. This has been a Media Clash production, and this has been the latest Bath Life Business Surgery. Bath together, always. Thank you.
Thanks.
Thanks, Greg.